Good morning, sir.
Good morning. Good morning. May it please the court. Nicholas Bolser here for the plaintiff appellant, Project Reflect. With the court's permission, I would like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
We have an interesting procedural issue for the court, for the panel this morning. During the course of litigation between Project Reflect and the defendant appellant, Ms. Anderson, in a prior case, a new claim arose in favor of Project Reflect. And the issue we faced at that point was, where is Project Reflect supposed to assert this claim? Can it assert it as any party could at a court with competent jurisdiction where venue is appropriate? Or by operation of the prior suit pending doctrine, does Project Reflect have to first seek permission from the court, in this case the Chancery Court, to amend its complaint pursuant to Rule 15 and to assert that claim? And of course, Rule 15, though it says permission must be freely given, remains discretionary. And so our understanding of the law and its application, and we find some support for this from a Second Circuit opinion, is that Project Reflect actually has the option to assert it either way. It's not controlled. It doesn't have to go one way or the other. It has that option. We think a careful application of the prior suit pending doctrine and res judicata principles supports that. The circuit court in this case, where we filed our new complaint, disagreed. Ms. Anderson encouraged the trial court, and the court followed this recommendation. The court just kind of looked at the issues and the documents and kind of assumed very broadly that the issues are the same, and so prior suit pending applies, and the court dismissed our complaint. We think, again, that looking very carefully at these res judicata principles, that was error. To get us there, I'd like to go ahead and give the court the fact.
Aren't the facts and the claims in both suits, particularly after the first suit was amended, aren't they the same?
If I may, are you referring to the last amendment where? I think I understand the court. Yes, Your Honor. The issue there, though, is that what we thought was just a courtesy to the Chancery Court saying, look, we have this claim, it's up on appeal. Just so you know, this might be coming into your case if the Court of Appeals says we had to come here. We didn't expect the court to actually rule on that. We asked the court just to stay any further proceeding and preserve it while it was there. Ms. Anderson put in motion, she actually set the hearing and forced us to go through with the hearing, and so the court actually accepted that, and right now those claims are part of the Chancery Court case. But we don't focus on that.
So we have two identical cases going on now.
They're not. I wouldn't say they're identical, and they're not going on, Your Honor. That case has not proceeded at all, and it's effectively been stayed while this appeal is proceeding.
But there's nothing that would prevent that claim from being asserted in the prior suit.
That's correct, Your Honor. We had
So
we had the option.
it could proceed there. Let me ask you a little bit about the party question here. I gathered from the brief that part of the argument was the School Sisters of St. Francis had some interest or claim here as well, but they're not parties to either suit, are they?
That's correct. They are not.
Okay. And so do they need to be parties of one or the other suit in order to get full relief for Project Reflect?
Not for Project Reflect, Your Honor. The way we get there is when we're looking at these res judicata principles, we're trying to figure out how the preclusive effect gets from one case to the other. And what Ms. Anderson argues is essentially that her count 3 and her counterclaim addresses the very issue here. And our point in addressing that was, if that claim addresses the very issue in our case, the issue has to be, did the School Sisters of St. Francis leave this property of their own accord, or were they forced out?
And was there any allegation either in the counterclaim filed in I'm going to refer to it as the prior suit to keep it in the suit that's before us, about the School Sisters of St. Francis vacating the property? Did anybody make that factual assertion in either case?
I think the kind of complicated answer, Your Honor, is yes and no.
That is a complicated response, I'll tell you that much. Yeah.
I'm trying to find the actual counterclaim to reference the language correctly. So this is Volume 1, record page 89. The claim for relief is paragraph 46, specifically any right or option purportedly created by the purchase agreement, residency agreement, and/or management agreement lapsed and became null and void when the School Sisters of St. Francis ceased their use of the property, thus breaking their chain of use, which has remained broken for almost 6 months as of the filing of this counterclaim.
Okay, so, but that's, you said that was in the claim for relief. It's not a factual allegation.
It's not. It's part of what that, as we understand what this count 3, this declaratory judgment claim is doing, is trying to fill the void, fill the universe, and say whatever Project Reflect might claim, it has no right to this property based on any one of these agreements or any provision therein. It's not specifically targeted as a factual matter to what happened to the School Sisters of St. Francis. We think, though, our position here today, though, is that if the trial court is going to enter a declaratory judgment or enter a judgment on this claim, the court's going to have to make some sort of factual finding as to what happened to the School Sisters of St. Francis, because that's what puts into effect or what brings into play our repurchase option under Section 7 of the contract for SSF residency. And our position has been that if we're going to actually get to that fact, the declaratory judgment statute requires us to have the School Sisters of St. Francis present in the case because they have an interest that's going to be affected by it.
Doesn't the prior suit pending doctrine apply to claims that were asserted and claims that could have been asserted in the prior action and the current action?
Prior suit pending does. Res judicata is a little different. I know the court's familiar with that. The kind of the standard 4 elements. The first one being that the underlying judgment was rendered by a court with competent jurisdiction. The same parties were involved. The same cause of action was involved in both
Neither
suits.
court has rendered a judgment, have they, other than to dismiss this case?
True, but we get to rate.
How could res judicata apply?
Res judicata applies because when you're looking at prior suit pending, there are 4 elements. Let me back up. There are 4 elements. The lawsuits must involve identical subject matter. The lawsuits must be between the same parties. The former lawsuit must be pending in a court having subject matter jurisdiction over the dispute. And the former lawsuit must be pending in a court having personal jurisdiction over the parties. Here we have no dispute.
I didn't hear res judicata in that.
It's not. That comes from the first element. The lawsuits must involve identical subject matter. The question becomes, how do you...
Respectfully, I don't think that doesn't sound in res judicata to me, but I may be wrong.
Well,
I always thought res judicata required a ruling and other elements.
Yes, Your Honor, but for determining whether two cases involve identical subject matter, you look at res judicata principles, and that's actually, we would point the court to a recent opinion.
All right, I don't disagree with that, but I get back to my question, which you have not answered. Doesn't prior suit pending doctrine apply to claims that were asserted in both actions and claims which could have been asserted in both actions?
It does, but...
And could not these claims have been asserted in both of these actions?
Not until you actually get into these res judicata principles and look at what happens to an unaccrued claim.
I apologize to say, but you've lost me.
Sure.
Hopefully they'll understand what you're trying to get at, but I don't.
Well, we know from Arnold versus Allstate Insurance Company, in that Judge Osman tells us that the res judicata principles will apply to this first element of prior suit pending. What happens, though, is we in our briefings point to the Supreme Court's decision in White versus White, which is a 1994 decision, which adds to these principles of res judicata this statement. A more complete statement of the rule includes the following. A judgment or decree is res judicata only as to the matters in issue. The adjudication to be conclusive should be upon the very point directly in issue by the pleadings, and a party will not be prejudiced by a judgment as to rights not then accrued. That's what we see as the issue, because we had this claim for breach of the repurchase agreement that did not arise until after that case had already been filed. It's a newly accrued claim. That's what puts us in the position of trying to figure out, well, where are we supposed to assert this claim? And some guidance on that, we look to the Second Circuit. This is SEC versus First Jersey, a 1996 decision. And this is addressing specifically these res judicata principles. There, the Second Circuit said, if a defendant engages in actionable conduct after a lawsuit is commenced, the plaintiff may seek leave to file a supplemental pleading to assert a claim based on the subsequent conduct. That's another citation to Federal Rule 15. But he is not required to do so, and his election not to do so is not penalized by application of res judicata to bar a later suit on that subsequent conduct. And that's the issue that we feel like we have here, is that we have this subsequent conduct, this demand that the repurchase option be performed and the denial to do it, which gives rise to our breach of contract claim under Section 7. And again, that puts us right back where we started, which was, again, where are we supposed to take this claim? And again, looking at these res judicata principles and how they don't apply to these unaccrued claims, we think we have the option of filing either in the circuit court or going back to the Chancery Court and asking for permission to amend.
But that brings you right around to having two suits on the same subjects in two different courts, and that's not favored.
I don't disagree with you, Judge Bennett, and we implored the trial court not to really put us in that position. We just wanted to flag that as an issue that was in the pipeline, because at the time there's a motion for summary judgment pending.
But they did.
They did.
But they did, and don't we have to deal with what they did rather than what you wanted them to do?
No, because I think we have some very strong issues up here on appeal, and the remedy, I think, is if the court reverses what will be the circuit court here, the appropriate course of conduct would then be to have the Chancery Court strike it and remove it because it shouldn't have been there in the first place. With my remaining seconds, I would like to address very quickly this issue of the frivolous appeal. We don't think we are in a position where this is an entirely obvious resolution how the prior suit pending doctrine should be resolved here. We think our claim has merits.
All right. Thank you, Mr. Bolso.
Thank
We'll
you.
hear from you on rebuttal. Mr. Belcher, please come forward. Good morning.
Good morning, and may it please the court. My name is John Belcher. Lindsay Chris and I represent Joan Anderson, both personally, individually, and as trustee, who are the appellees in this case and the defendants in the underlying proceedings. Before I jump in, I'd like to answer two of the court's questions. Judge McBrayer, you asked, did the prior litigation detail factually the circumstances of the nuns leaving? It did, and as a matter of fact, there was detailed affidavits filed, and that case is up on summary judgment. And one of the central claims in Ms. Anderson's counterclaim, which is in the record, and we also quoted in our brief, these very documents at issue, this residency agreement, management agreement, paragraphs 46 and 47 of her amended counterclaim, she alleges that those documents, quote, lapsed and became null and void when the School Sisters of St. Francis ceased their use of the property, thus breaking their chain of use, which has remained broken for almost 6 months as of the filing of this counterclaim. A text was attached to one of the pleadings from one of the sisters detailing their leaving that was addressed in Ms. Anderson's affidavit, and we respectfully contend that was brought up in the prior litigation. Ms. Anderson's counterclaim went on in paragraph 47 to say she respectfully requests that this honorable court declare that Project Reflect does not have any right, title, or interest in the property that would derive from either of those same two documents which they've attached. Judge Clement asked a question, doesn't prior suit pending apply to claims that were asserted or could have been asserted? And the answer is just an emphatic yes, and we quoted that in our brief. We would quote to the Fidelity case. Fidelity says, prior suit pending, quote, applies not only to issues actually raised in the first suit, but also to issues that could have been raised regarding the same subject matter, and that all issues which are made or might be made concerning the same subject matter must be determined in that court which acquires jurisdiction first. So we think that's just clear law that it does apply not only claims that were asserted, but claims that could have been asserted.
Mr. Bolso, in the latter part of his argument, was suggesting that he had the option to assert a claim under certain circumstances. What is your position in that regard?
You know, we disagree. We think we respectfully contend this is a frivolous appeal, and that second lawsuit never should have been filed because those claims were pending, actively pending in the prior litigation. In the prior litigation, Project Reflect sued, alleging essentially that this deed was fraudulent in some way. Ms. Anderson answered, attached all the closing documents from 2005, which clearly showed it was a proper transaction from 2005, but went a step further and filed a counterclaim which said, what I just quoted, that Project Reflect should not have any right under either the purchase agreement or the management agreement. That went through and was on the eve of a summary judgment hearing when Project Reflect went out and filed this second suit. So at the time they filed, the claims, it's not like Fidelity where they could have been asserted, they were asserted by Ms. Anderson. They were briefed and they were pending before the court. So thus the circuit court said, prior suit pending, and promptly dismissed the second case. Project Reflect appealed, and where this really gets interesting, and I think bears on our frivolous appeal claim, is after that, they amended the Chancery Court, the prior case, to now assert identical claims to the circuit case. And I mean, carbon copy, I guess that's a dated term, but identical pleadings in both cases. So whereas it was brought up by Ms. Anderson before, and could have been brought up at any time by Project Reflect before, they went and amended and explicitly brought it up. And so currently in two separate cases, there are the exact same claims being pled. And we don't think that's proper. It puts Ms. Anderson in a terrible predicament. They've got two lien lis pendens filed on her property. She's battling in two courts, which is obviously expensive and time consuming. And it creates a terrible muddle as to conflicting rulings. And I don't know if they were to prevail in this appeal, you know, they then have two active litigations with the same claims pending. The first case has not been stayed. Not much has happened because the summary judgment's been under advisement and this appeal's been going on. But right now, that's an open, active case. So we believe that the circuit court in the second case got it absolutely right when they promptly dismissed this for prior suit pending. The elements of prior suit pending, in some cases, if we read through the case law, sometimes it requires some extrapolation. Do you have the same parties or these agents or proxies? Or in this case, no extrapolation is required. It's the exact same parties with the exact same issues from the exact same template of a document. We even excerpted the style and first three paragraphs of the document. And the exact same issues are now pending in two court. So we think that this was a clear and correct call by the circuit court, and we would respectfully request that they be affirmed in their trial court's dismissal of the second case. And then we also believe that this is a frivolous appeal, and we've raised that in our brief, because it's not supported by the law, number one. And number two, in order to try to make its argument, Project Reflect has made a number of assertions that just aren't accurate, with no cites to the record, and that are inflammatory, that there was withheld evidence. There wasn't. They waited some 16 months to serve discovery in the first case, and as soon as they served discovery, they got responses. And they claim, well, that evidence was withheld because we didn't have it for the 16 months we didn't serve discovery. But there's no cite to the record for that. There's no finding of that. There's been not even a motion or an allegation of that in the prior litigation. It's just something they put in their brief, I guess, to try to give justification for the approach they've taken. There's a discussion of White versus White. I think that's really the case. I know they've cited several cases, but that's the case they centrally rely on. And that's distinguishable. That's a case where there was a declaratory judgment action to determine whether someone was dead for an insurance policy reason. The court didn't come to the ruling that they wanted, and years later, they tried again. They said, well, 6 or 7 years have passed.
Right.
Now,
I mean, I think what they're saying, though, is the analog here is the letter reflecting the arrangement on handling of expenses is that sort of similar situation. But I guess the counter is, well, that letter came and sufficient time for it to be included in the prior suit.
Because, yes, correct, Your Honor, because the prior suit was still pending. So at any time, they could, at any time, and in fact, they did, after they filed the appeal, go back and amend. They've always had their full slate of remedies in the prior suit. If they want to try to amend, if they want to try to add a party, if they think the school sisters are a necessary party, if they want to try to dismiss the counterclaim because they think it's insufficient, if they want to ask for a more definite statement, they have their full slate of remedies in the prior litigation. And with the law, our read of the law is that they're required to go through those remedies. And if the court gets it wrong, then they appeal that decision. They don't go and file another suit and then another suit.
And the original transaction in 2005, that was between Project Reflect and Mr. Anderson.
Correct, Your Honor. Okay. There's a deed. The Project Reflect had an alter ego entity, the Reflect Mission Community, but that is correct, Your Honor. And then the purchase agreement was between Project Reflect and Ms. Anderson. There was a separate residency agreement between Project Reflect and Ms. Anderson that the school sisters also signed off on. And Ms. Anderson details in her affidavit in the prior litigation how one of the school sisters died and the other one eventually moved out. And there was an unbroken succession there. So we think White versus White is distinguishable because White versus White, the second issue, the second case arose 7 years after the first case was concluded. And that's not what we have here. Here they had the opportunity to raise any issue they wanted in the prior case because, again, same subject matter jurisdiction, same personal jurisdiction, same issues, same parties. But they did not avail themselves of that. They chose to go to the circuit. And interestingly, they went to the circuit court on the eve of the summary judgment hearing in the first case.
You mentioned that the first case, the Chancery Court case, there is no stay. It's just simply the court, the Chancellor has not yet ruled upon the summary judgment motion.
Correct, Your Honor. It's not stayed. The summary judgment is under advisement. There's also a motion to dismiss their amended complaint that's been heard and is under advisement.
But nothing in the first case is before us.
Correct.
For this court.
That's correct. The only thing before this court is the narrow issue in the second case, the circuit court case, whether the trial court properly dismissed it pursuant to prior suit pending. We respectfully contend that they did, that should be affirmed. And then secondly, we believe this is a frivolous appeal for the reasons described, and we would ask for an award of attorney's fees. One of the cases we cited for the frivolous appeal argument involved res judicata and was a very similar circumstance where someone had sued, and then I know this is prior suit pending, not res judicata, but it's a similar species, and someone had sued and then sued again, and the Court of Appeals awarded fees because they said that there was no basis for that second suit. Furthermore, there was supplemental briefing, reply and surreply, and one of the issues, another issue we've taken with the position they've asserted in their papers is that somehow Project Reflect was unaware of its own documents. It was unaware of the closing documents. There was a purchase agreement and a residency agreement and a settlement statement and a deed and a canceled check and all of the things that had gone through closing. Well, they signed those, and Rick Mills, we filed his deposition. That was filed in the first case. It's been filed before this Court of Appeals. Rick Mills acknowledged that, and they tried to retreat from that in essence to say somehow that this transaction only came to light to us late. But in fact, Project Reflect has been on actual notice of this transaction for 21 years. They participated and signed the documents in 2005, and to the extent they forgot about it, when they filed this lawsuit against Ms. Anderson and said, whoa, why do you have the deed to this property? She promptly filed those documents in the Chancery Court, and they've been part of the Chancery Court record since early 2023, so 3 years now. So for those reasons, unless the court has any questions, I know I've got a couple minutes left, but we would respectfully request that the circuit court be affirmed and that there be a finding this is a frivolous appeal, and that Ms. Anderson be awarded her fees.
Thank you, Mr. Belcher.
Thank you.
Mr. Bolso, your rebuttal.
Thank you, Your Honor. I want to pick up a little bit how this claim develops. I think that will shed some light on questions that you, Judge Clement, asked and you, Judge Breyer McGass, asked as well. We have this June 2022 letter that we uncovered in discovery. It's page 120 of volume 1 of the record. I think there's been a little bit of misunderstanding about our allegations of concealment. We're not arguing anything against counsel, saying that counsel didn't produce this in discovery. Our position was simply that we didn't know about this letter. Project Reflect did not know about this letter until it received it in discovery. Ms. Anderson did not contemporaneously send this to Project Reflect. This was just addressed to the sisters. That's significant because there's been some back and forth between the parties about what's actually happened with the School Sisters of St. Francis. Ms. Anderson's position is that they left of their own accord. We viewed that somewhat suspiciously. We knew that she could kind of ask them, she could make things unpleasant and kind of force them out, and if they're leaving voluntarily, there's an argument then that Ms. Anderson has complied with her obligations under these agreements. But this letter is the first definitive evidence we have that Ms. Anderson did not do that. And so once we have this, we don't have a claim quite yet because we have to demand performance of the repurchase option. At the time we get this letter, we have not demanded that Ms. Anderson perform. It's not until we do that that we actually have the claim for breach of Section 7. And once we demanded Ms. Anderson perform, that was August the 16th of 2024, and she refused, that's when we finally have this claim. And so we have this issue about, well, could you have asserted this claim in the prior suit? After we received this letter, no, because the claim hadn't accrued yet. It's not until it accrues that we can actually assert it, and that puts us right back to where I started, which was, okay, what do we...
The difference between this case and White is that the claim you just mentioned accrued while the Chancery Court case is pending, versus in White, it accrued 7 years later.
Well, the issue in White was the death of an insured, and so at one point the court entered a judgment saying, no, there was a jury result that said, no, there's insufficient evidence right now. Years later, they came back and said, okay, well, now more time has passed. We're pretty sure he's deceased now. The claim had accrued before the case, and res judicata still did not apply. We think res judicata would not apply for all the more reason here because the claim had not accrued, and we've produced the authority for that in our brief. But that's what we view as kind of the fundamental issue here. There are perhaps two fundamental issues. One is this issue of whether the claim accrued, when the claim accrued, and how prior suit pending applies to an unaccrued claim like that. And then this other issue about what exactly is the declaratory judgment supposed to say, and how do you frame it so that you can actually get preclusive effect to bring into play the prior suit pending doctrine. We see issues on both fronts with that declaratory judgment, the issue being that we're missing a necessary party.
All right. Thank you, Mr. Bulso and Mr. Belcher, for your arguments. We will take this matter under advisement.
Thank you.